Welcome everyone to our webinar today. It's a WHS legal update, essentials for in-house counsel and business managers. My name is James True. I'm a practice group leader here in LegalVision's employment safety team, and I'm joined by Dickson Wu. He's a senior lawyer in the team. Before we get started, just a few quick housekeeping items. So number one, you'll receive a recording and the slides in your email afterwards. Throughout, you can submit your questions in the chat box. We'll do our very best to answer them, the ones we can get to at the end. And then finally, there will be a feedback survey for you after the webinar. We ask that you do please fill that out. We want to make these webinars as useful and helpful as they possibly can be, so the more feedback we can get from you, the better to improve them. You're also eligible for a call with LegalVision's team to discuss how we can help your business and your legal needs. So if you're in-house counsel, you can also learn how our desk extension program will reduce your in-house your in-house team's workload. Just leave your contact details in the survey at the end of the webinar. So in terms of what we're going to be discussing today, we'll run through an overview of your WHS obligations to set the scene with that, and then talk about two key recent updates to WHS laws, as well as then working through some steps that you and your business can take to ensure compliance, and then we'll answer your questions at the end that we can get to. So we'll get straight into it and kick off. I'll hand over to Dickson. You can run us through an overview of WHS obligations.
Great, thanks so much, James. So as James mentioned, I'm going to start with just really setting the scene and giving us a brief overview of the actual WHS obligations. And one thing I wanted to note as we kicked off is just to flag that we're going to be using the language of WHS, or work health and safety, throughout this presentation. And that's mainly because there were model work health and safety laws which were developed in 2011 by Safe Work Australia. The purpose of that was just to improve the consistency of work health and safety standards across Australia. Now, all Australian states and territories have since implemented the model WHS laws, apart from Victoria. Now, if you're based in Victoria, you might have heard of OHS, or Occupational Health and Safety, but everything we discussed today, it's still going to be functionally relevant for you, for your business, and for your workers. So as we think about WHS obligations, one of the best way to actually understand and approach what these obligations are is to actually consider three key duty holders under WHS laws. And the three key duty holders are firstly the PCBU, or the persons conducting a business or undertaking. Secondly, your officers or senior managers within the business. And thirdly, your workers. So let's work through each of those duty holders in a little bit more detail. So we'll start with the PCBU, the persons conducting business or undertaking. Now, PCBU covers really any kind of business, can include sole traders, companies, partnerships, and unincorporated bodies or associations. And under WHS laws, the PCBU has the primary duty of care to take reasonable steps to ensure the health and safety of its workers and of others in the workplace. Now, this could involve a lot of different things, but examples could be just providing and maintaining a safe workplace, providing adequate and accessible facilities for workers. It could be providing information, training, instruction, and supervision in relation to safety matters, as well as just monitoring the health of workers and the conditions at the workplace. Now, there's a really important principle here of the PCB taking reasonable steps, or doing what's reasonably practicable in the circumstances. And what this means in practice is that, well, for a small business, what's expected, what's reasonable for a small business is going to be different compared to a large corporation when it comes to taking those steps to ensure a safe working environment. It also means that some risks need to be fully eliminated while others don't. And there's lots of factors that are relevant here to determine what's actually reasonable or reasonably practicable in the circumstances. And you'll see a few of them on the slide there. Could be considering the likelihood of the risk occurring, the degree of harm that might result from the risk, the knowledge about the risk and ways to manage it, as well as the availability, suitability, and just the costs of the options to eliminate or minimize the risks that have been identified. Moving along then to the second key duty holder, the officers in the business. And in some of your pre-submitted questions, we had a few questions about officers and who they are. So hopefully this starts to help explain that for you. Now, officers can include company directors or secretaries, and they're also people who make decisions that have an impact on the whole or a substantial part of a business. And this could be your senior managers and your C-suite executives. Now, if you're attending today and you're not an officer, it's worth noting that you may be involved in helping the officers of your business understand and comply with their obligations. And WHS issues could be raised to you by your officers to manage and handle. Now, what's required of officers? Well, work health and safety laws require officers to exercise due diligence to ensure that the PCBU complies with their WHS duties. And how officers can actually exercise due diligence is by taking reasonable steps to do a few things. Firstly, to acquire and keep their work health and safety knowledge up to date. They can take steps to understand the hazards and risks associated with the business, to ensure that suitable resources and processes are in place and being used to manage WHS risks, and also to ensure that appropriate reporting processes are in place and being followed for WHS incidents, hazards, and risks. So one takeaway here is that officers, individuals, can actually they can be held personally liable and have their own personal duties under WHS laws. Moving along to the third and final key duty holder, it's the workers of the business. Now, workers are really anyone who carry out work in any capacity for a PCBU, and they include employees, contractors, apprentices, trainees, and volunteers. And their duty under work health and safety laws is mainly around taking care of their own health and safety and of others in the workplace, as well as complying with the reasonable instructions and policies from the PCBU. So what you hopefully have seen here from a really brief overview of the WHS obligations and the key duty holders is that hopefully everyone's really working together to look after each other's health and safety, to set policies, procedures, processes in place so that everyone is keeping it front of mind and everyone really is involved in taking steps to manage work health and safety risks. So that's just to set the scene. I'm going to hand it over to James now to talk about some of the more recent updates to work health and safety laws.
Thanks, Dickson. Yeah, thanks for the overview. Really important to understand that at all factors, all parts of the business, there are duty holders, and a business that has everyone complying is going to be a safe business. Some of the key recent updates, the first one I want to talk about is psychosocial hazards. So we'll talk about what are they and what gives rise to them. The changes to WHS and OH&S, so for Victoria as well, in relation to psychosocial hazards came into effect about a year ago, a bit over that. But what we're really seeing now are the regulators, so people like Safe Work, WorkSafe, start to enforce the obligations. And so we're seeing complaints from employees, and we're seeing, either scheduled or random visits to employers from inspectors. So while the legislation changes is not immediately new, certainly the enforcement regime is. In terms of talking about what actually are psychosocial hazards, these are effectively non-physical risks. So they're hazards at work. Aspects of work and situations that could cause a stress response, which in turn can lead to physical, psychological harm. So things like anxiety, depression, PTSD, sleep disorders, they are the kind of key risks coming out of psychosocial hazards. And the changes to the law are basically that now, in a way that law has historically focused much more on physical safety issues, the law is expressly acknowledging now that psychosocial hazards exist within workplaces and that businesses need to take those reasonable steps or ensure so far as is reasonably practicable, as Dickson's been through, everyone's safety basically in relation to psychosocial hazards. Now, in terms of going into the more, I guess, the question of, well, what are they? They are effectively, common ones are going to be things like job demands. So that can be high workloads, unreasonable, excessive time pressures placed on employees. Poor support could be something like, if a worker didn't have adequate support from, say, managers or from their colleagues, maybe they weren't provided with adequate training or resources in order to do their job. Lack of role clarity. Things like frequent changes to a worker's role or even ambiguous responsibilities and expectations where they're left in the dark about their expectations. Again, these are all now acknowledged as a risk to health and safety under the umbrella of psychosocial hazards. Poor organisational change management, that's typically a failure to consult or communicate with your workers during periods of change. Inadequate reward and recognition, things like lacking some positive feedback or rather even high levels of, say, unconstructive or even negative feedback. Obviously, this is not a sign to say you're not allowed to performance manage your employees. You're always still going to be able to do that. You'll be able to give them negative feedback. But where it's overwhelming or unwarranted, that definitely can pose a safety risk. Remote work, isolated work, that can be sort of two factors. It can be working in locations, with long travel times, sort of geographically isolated locations. Or it can just, be your employees who are working from home. And there are obviously issues that arise, just by virtue of being isolated in that sense. So there are sort of two aspects to it, and a lot of risks which come with that. Poor workplace relationships and interactions, probably a more obvious one, but things then like violence, aggression, bullying, discrimination or harassment from colleagues or even from your clients as well. Absolutely now, all of these things are expressly considered as psychosocial hazards within a business. And now an expectation from regulators that these form part of your WHS approach. Want to move on then to, what actually gives rise to those risks, and they're very much intertwined. Lots of aspects about your business can create a psychosocial risk. Typically, and this is guidance that we see from regulators like Safe Work, who have put out a lot of material in terms of how to identify these risks and where do they come from. Things like the design of work, so coming back to things like job demands and the types of tasks you're actually asking of your employees. So if the job is designed in a way that someone just has too much work on, then that actual job design is something which is creating a risk or creating a hazard. Your systems of work within your business, so your management structure, how do you organise and support your employees? So if you've got a system which doesn't really allow people to maybe reach out for assistance from their supervisors, something like that, if they've got limited ability to do that, you're potentially introducing hazards. Another factor would be even just the physical design and layout of the working environment. So exposure is a common issue, say to unpleasant, hazardous working environments. There's a big crossover there into talking about, I suppose, physical risks. So say, even loud environments, although it creates a physical risk, it can also be a psychosocial risk in terms of the other sorts of injuries that can develop from that type of, call it an unpleasant physical workplace. That leads into, loud noises, dust, vibrations, all of those things can create poor physical environments and then also create psychosocial risks. Something which we're going to sort of segue into one of the next updates in the law is talking about workplace interactions or behaviours. This can be things just, disagreements or disparaging, rude comments, but absolutely the things which you're probably as a business already dealing with and have an approach to: discrimination, harassment, bullying, all of those interpersonal workplace issues that you might see Historically, they've been kind of in the realm of your, an HR issue or an employment law issue. But with the law changing as it has, these are now safety issues. The other update on the WHS front is new penalties, and they're going to come into effect later this year, certainly in New South Wales anyway, and I expect other states and territories will soon be following suit. But they're very significant increases. So, for example, for your most serious offences in New South Wales, your increase is going from a current maximum penalty of 3.9 million all the way up to 10.4 million. So that's an extraordinary increase on penalties, and is a very strong indication of where enforcement is going to go and how serious the regulators will be about enforcement. For officers, it's moving from 800,000 to 2.1 million, and for individuals from 400,000 to 1 million. So all the penalties are much more than doubling, and that's a very significant increase and very much a big warning to businesses. So we will move on then. The other update in this space is in relation to sexual harassment. And this is still very much entwined with your work health safety type obligations, although it's under sex discrimination legislation. But recently the Human Rights Commission has got new enforcement powers that came in December. And under the Sex Discrimination Act, organisations or your business will now have a positive duty to eliminate, as far as possible, so discrimination on the grounds of sex in a work context, sexual harassment in connection with work, sex-based harassment in connection with work, conduct creating a workplace environment that's hostile on the grounds of sex, and then any kind of related act of victimisation. The key focus here is sexual harassment. Now, again, just like all your discrimination, harassment, bullying type issues, which have historically been your employment HR type matters, they've found their way into the WHS space. And then now in relation to sexual harassment, they're being improved in terms of enforcement mechanisms for employees there. But the critical thing here is your positive duty. We'll talk mostly about sexual and sex-based harassment here. Sexual harassment, we have a clear definition of this being any unwelcome conduct of a sexual nature that occurs in circumstances in which a reasonable person, aware of the circumstances, would anticipate the person being harassed, might feel offended, humiliated, or intimidated. Now, I've just read out the legal definition there. What this means, in essence, is sexual harassment is an extremely low bar. Any unwelcome conduct of a sexual nature, again, that's a very low bar. And then a reasonable person test. So whilst context can be critical to determine whether a particular instance is sexual harassment, what absolutely is not taken into consideration will really be whether the person, the harasser, in this instance, is meaning to harass someone. So we have a very low bar for what can be sexual harassment in the workplace, and that's really the key takeaway. Sex-based harassment is really behaviour. We're talking about sexist and demeaning behaviour. It doesn't necessarily have to be sexual, but on the basis of someone's sex. So again, there's a reasonable person test. The examples that the Human Rights Commission gives is talking about when a person is degraded, if they're put down or disrespected because of their sex, or a characteristic generally associated with people of that particular sex. So those are, in a sense, they're not necessarily new concepts, but the new factor for businesses is that you've got to be taking proactive steps to address the conduct. You don't have to have an instance of harassment to breach the law. there can be a breach where you haven't taken reasonable and proportionate measures to prevent it. So that's very much in line with your WHS obligations here. Everything now is about making sure you're actually taking steps to prevent things occurring, rather than necessarily just being reactive. So with that in mind, what your business is going to need is to actually take some practical steps to ensure you're complying with your WHS obligations and this new positive duty under the Sex Discrimination Act. So if we move on, I'll speak to some of those things that you can do. First up is risk assessments. So you want to conduct really a full assessment of your business for risks. Understand whether, if we're talking about the psychosocial issues, is your workforce, overworked, under-supported? Some of these things might already be evident to you and you can just observe them in terms of carrying out that assessment. Others you might actually need to explore in depth to, I guess, uncover whether there are actually issues that you can do something about. And consultation is absolutely a way you can make that assessment. We'll talk about consultation shortly. Identifying risks in the workplace, well, that really is about finding things, situations that could maybe cause harm to people, is really what identifying risk is about. If we're talking about psychosocial risks, we know that they can arise from the physical work environment. So that could even be things like, can your workers extract themselves from difficult situations? So, are they locked into, being stuck with an aggressive customer? Is there a way they can actually get away from something like that? Other things that can have an impact would be things like, equipment, materials, substances used. That's more on the physical side of things. But, as we talked about, loud noises, vibrations, all of those types of things, particularly long-term exposure, can create psychosocial risks. And then other factors, just your tasks and work tasks. Well, how are they performed? So think about your workload. Think about how that's actually designed. Can you find ways internally to make sure that some of your employees aren't being, completely redlined, while you've got others who aren't doing much at all? So actually the design of your business, workload allocation, resource management, those things are things to actually go and examine to see if we're creating risk. Yeah, certainly management, and that structure that you've got in place. Is there a structure to actually ensure that the safety of your workers is being managed? Do you have policies that allow workers to raise issues? You want to have a reporting mechanism, the ability for people to raise issues. Workers, in a sense, even when we're talking about psychosocial issues, they can be the front line of your risk assessment. They're the people who are, at the coalface, either literally or figuratively, who are there to actually identify risk. And if you've got a culture of making them just deal with it, you're not going to know about it, and that's going to limit your ability to actually take these reasonable steps and comply with your obligations. So allowing them to actually do that is pretty critical. It kind of feeds into a culture point, I think, particularly in relation to sexual harassment. As a manager, as a leader in a business, you're going to need to understand the culture in the organisation, and is that something which is increasing the likelihood of instances of any kind of WHS breach, a psychosocial issue, particularly sexual harassment. Is that culture increasing the likelihood of those things occurring? So absolutely make an assessment of culture, but also things like your physical design of your workplace can be very important too, even in the context of things like sexual harassment. Do you have even things like, meeting rooms with, clear glass leading into them? Are there offices which can have doors that are shut, allowing, isolation where there are power imbalances between employees? And so physical design actually can then lead into creating a higher risk for instances of sexual harassment. Obviously, when you put all of those things together, so they are worth exploring. Moving on to, I guess, those ways of how do you actually go and identify risk. Now, every business needs to have a risk identification process in place. It can be as simple as just inspecting the workplace for hazards. Going around and looking at the physical workplace is a legitimate way for a business to identify risks, as well as then also for all the kind of non-physical sides of things, just reviewing it. What is our structure? How does our management and reporting work? What are our what policies do we have in place to allow people to raise issues? So it's actually just inspecting and reviewing. Another way to do it is to consult your workers, maybe even your suppliers, about health and safety issues. And so consultations are a really critical one, and I touched on that earlier, and we'll speak about it a little bit more. There's certainly research that you can do, again, as a sort of a leader of your business. There's a lot of information provided by regulators. For those of you who are clients of us, we provide you a lot of information frequently about new focuses from Safe Work, new hazards, materials, all those types of things. And Safe Work itself, WorkSafe in Victoria, well, they'll put out guides and codes of practice, as well as materials in relation to specific issues that businesses may face. That's quite critical, because when you're making an assessment of your level of compliance and whether you have taken those reasonable steps, one of the factors that gets considered by the courts is, well, how much do we know about that particular risk? Has it blindsided everyone? We didn't know it was a problem, or is there a lot of material out there which said you should be, squarely aware that this is a problem? And so actually not being, blind to those things and actually going out and investigating what's known about particular risks is really important, because it's very relevant to your legal compliance. And of course, you can take advice from a consultant. That relates to both physical and non-physical risk. There'll obviously be people who can come through and make an assessment of your physical environment and any particular risk there, as well as then the psychosocial hazards. Other things you can use, I mentioned consultation, even things like now using wellbeing surveys, 360 reviews. These are all now legitimate ways to approach WHS obligations. And again, making sure you've got a documented process there, so that if an inspector ever comes knocking, you can say, well, one of the ways we assess risk is by making those types of surveys, consultation approach, making all of that available to employees so that they can identify issues. And that very much leads into complaint and dispute resolution mechanisms. So part of your workplace policies, you want to have policies that set out everyone's obligations, and dealing with things like, you want a WHS policy, you want an anti-discrimination, harassment and bullying policy. If you've got employees who are working from home, you want a working from home policy as well, and any other number of policies which might deal with specific safety issues in your business. But they should all have a dispute resolution mechanism in it, and obviously a mechanism for employees to raise issues. For some businesses in the more physical space, even just giving employees a right to stop the job if they identify that there's any kind of safety issue, and having a clear policy about a right to stop the job is a very effective safety mechanism and a very useful way to demonstrate that you're complying with your obligations, so that no one can turn around and say, well, I felt pressured to do that dangerous thing. Exact same principle applies in the context of psychosocial hazards, sexual harassment, the type of things we've been talking about today. The other thing then is, I guess everything we've talked about in terms of things you can do in this space, managing these duties, I think it can be boiled down really into two key issues. Number one, it's leadership. It's obviously very relevant for everyone joining us here today. And then consultation. Now, leadership in this space best achieved by making sure your managers are aware of their duties under the WHS laws. And if they understand they've got obligations in their personal capacity, well, that tends to make them engage a little bit more, comprehensively with the issues. Engaged leaders tend to drive engaged workers, and so that really can be the driver of, say, a positive culture in your workplace. And the WHS and now the sexual harassment laws are increasingly concerned with matters of culture in a business. And in fact, changes under the New South Wales legislation now talks about imputing conduct to the corporate entity. And what that basically means is that if the corporate entity is going to be penalised under the laws, the way of actually determining whether the corporate entity has actually acted in a particular way is looking to things like, it can be the conduct of the board of directors, but also whether a culture existed within that organisation to allow that type of behaviour. So it's new ground for this type of legislation. It's the same with the sexual harassment provisions that talk about if you've actually allowed or got a culture, a hostile culture in the context of sex-based harassment. Also another way to demonstrate that you haven't complied. So culture, now very much a legal concept. And so, you want your leaders to be aware that poor culture is poor legal compliance. Consultation is the other aspect. Now, it's a requirement under the WHS laws, and it's very simple if we're talking about managing physical risks in a workplace. So seeking feedback from an employee on physical risk, pretty uncontroversial. It's have you identified any issues? And someone can say, oh yeah, look, the fridge in the kitchen is leaking, and it's a very uncomplicated thing for someone to raise. No stigma associated with anything like that. Obviously, a bit different when we're talking about psychosocial hazards. The nature of those risks can be very personal, they can be very private, and yet there's potentially a stigma involved. So we do see a lot of hesitation to discuss those types of things from a worker and from a worker's perspective. That doesn't mean you just don't do anything about it. Ways you could still consult in maybe a more sensitive or useful way, really. Surveys, anonymous surveys, toolbox meetings, just general discussions, one-on-one catch-ups with managers, privately, or you may have WHS committee meetings and that type of thing. So there are definitely, we've got new issues identified under the law, new risks, new hazards, being all your psychosocial issues, and so it's going to ask businesses to be a little bit new, a bit creative in terms of how they come up with ways to deal with it. So that's a lot that I've worked through there. Hopefully those are some helpful takeaways. That actually concludes the main part of the webinar before we get to questions shortly. But for now, I'll just hand back over to you, Dickson.
Yeah, thanks, James. Super helpful. A few quick announcements of things that you can access, events that are coming up as well. So firstly, we've got a publication that you can access. It's a safety essentials for SMEs. So there's a materials panel that you can use to download that. Otherwise, you can scan the QR code there as well. For those attending who are in-house counsel, you may also be interested in downloading our general counsel toolkit from the materials panel. And that's a toolkit that will help you streamline operations, reduce costs and drive efficiencies, so your in-house team can focus on strategic priorities. So a couple of free resources there, which will hopefully be useful for you and your business. And we also have an upcoming event next Tuesday. So if that's of interest to you, then feel free to register for that one with the link there as well. Thanks to everyone who have submitted questions, both before the webinar and during. We're going to answer them very shortly, or as many as we can. Just to give you a little bit more time to submit them, I'm just going to take a quick minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business will actually get unlimited access to our team of specialist lawyers. That's for all of your business's usual legal needs. It's kind of like having your own in-house counsel, but for a fraction of the cost. Some things that we can assist you with include unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. We also offer a membership for in-house teams and general counsel, which James alluded to at the beginning. That's our desk extension, and that's to help you manage your high-volume business as usual legal tasks. What we'll do, our lawyers will invest upfront in understanding what's important to your business and really just work as an extension of your in-house legal function. So if you'd like to learn more about our membership or our desk extension and how we can help your business meet its legal needs, then feel free to request a free consultation when the survey appears at the end of the webinar. All right, time to move to Q&A then and to answer as many questions as possible. So one question that we've received is, what is the best way for employers to manage and assess the risks for employees working remotely in their home environment? Or is this in fact just outside an employer's obligation?
Sure. So answer the last bit first. It's definitely within an employer's obligation. Those WHS duties extend to anywhere the employee is performing work. If you've got someone working from home or somewhere where you don't have any, I suppose, ability to control the physical environment, you're not there, you're not watching them work, you're not controlling that like you would when they're in an office. Your obligations at law, they kind of acknowledge this. As we talked about, you need to ensure so far as is reasonably practicable their health and safety. So it's a question of, well, what can you do? Now, a really common way for businesses to deal with this would be to have an employee carry out a home workplace self-assessment, basically, a checklist. You can provide the employee with a checklist of things to look at in their environment so they can work through it, make sure that their space of work is safe, and then provide that to you and satisfy you that it's safe. Typically with home workplaces, it goes into things like, are there trip hazards? Do they have big long extension cords running to their computer that they could trip on? Even goes into details around, is your computer set up at the right height? You don't want employees working from home, sitting on the couch with their laptop. They're big risk of back injuries. You don't want them sitting at a dining room table trying to work in a poor ergonomic setup. So something like that type of checklist is a way that you can take some steps, knowing that you can't go in and watch them work all day and control that environment. But the law wants you to do something. So a working from home policy and a working from home checklist is a really sensible way to do it.
Thank you, James. Another question that we've been sent through, and we've obviously focused a lot on the psychosocial hazard side of things. It's related to that. How should companies go about investigating psychosocial claims? And where is the line between a claim of this nature and a workers' compensation claim, or are they effectively the same?
So they're different in the sense that you need to look at your obligations under WHS law. So when you've got a psychosocial issue, someone raises a claim, it might be a stress or a bullying claim, you've effectively been put on notice that there's a risk in your business, or there may be a risk in the business. So from a WHS law perspective, you want to carry out an investigation, understand, okay, is there a risk? How severe is it? Is it likely to keep occurring? What control measures can we implement? What can we do to make sure this doesn't happen again? When you've got your workers' comp claim, it's a different jurisdiction, and there's a different, level or a different burden of proof or standard of proof in a workers' comp claim. An insurer will investigate to decide whether or not they'll accept liability, but they're only really answering a question of, was there an injury and did it happen in the context of work or during the course of employment? So whilst they do an investigation, you don't really want to rely on their investigation because they're looking at different things. They're just trying to answer those two questions. Your investigation will go far more into if there is an issue, maybe what are the primary causes of it, and then going further into, well, is this a broader issue? If it is, what can we do to fix it? So upshot is, don't rely on a workers' comp investigation to be determinative of whether you've got a problem in your business. But it still can be useful, particularly if that workers' comp investigation is saying what you want it to, i.e. there's no claim here, but it doesn't get you off the hook from a WHS perspective.
That makes sense. Thanks, James. Another question that relates to psychosocial hazards. So you mentioned working excessive hours as a potential risk or hazard. The question here is whether there's a general working definition of what might constitute excessive hours, as well just tips for how to best talk about it in the context of discussing psychosocial hazards.
Sure. So the answer is this one's super grey. It's very contextual based on different industries. The nature of the work, you're mainly looking at excessive in the context of safety. Is it now posing a risk to health and safety? And that'll be different. If someone's operating a crane or driving a forklift, then their level of tired may create an extreme risk to health and safety, whereas someone working in an office, it will be less in terms of the potential negative outcomes. Having said that, it doesn't mean that office workers or people with non-physical risk environments, it can then just be worked excessively, because we know that then creates all of the psychosocial risks. Fatigue definitely, and fatigue management is really important, and so it's really taking, in this instance, you've got to take a really holistic approach. You can work people pretty hard for a short term, as long as they get a chance to rest afterwards. It's the kind of prolonged hard work. Lots of things will factor into that. Someone who's working extremely long hours, who is very unsupported, will have a worse experience than someone who's working long hours in a really rewarding and highly supported role. So context becomes super critical. There's no X number of hours is now deemed too much. But typically, it's just making sure, once you've identified their longer hours, if they're creating a risk to health and safety, think about the ways you could mitigate that. And typically, it's some kind of time off, rest and recovery afterwards.
Yeah, it makes sense. So a lot of this, as you say, based on the context, based on the nature of the work, maybe the intensity of the work, the support that they might be receiving in doing the work as well. A lot of that will come into play. Yeah, yep. Great. There's a couple of questions we're going to try to combine here. So the first one is around, in a kind of labour hire arrangement, who's responsible for work health and safety obligations? And the recent question that came through was, what happens in relation to employees working on client sites? So I'm taking that question to be, well, we have less control over what's happening on a client site, and I guess that can be connected to labour hire as well. Yeah,
that's right. So the strict answer is you're still liable. They're your worker, but you need to come back to your obligations, which is you've got to ensure, so far as is reasonably practicable, their health and safety. Now, in the context of labour hire, you're going to have quite limited ability to control the environment, but there are still things you can do. So if you need to discharge that duty, it might be even things like, in your labour hire, in your agreement with your client, getting them to warrant that, A, they're going to look after your employee and keep them safe. But you might put some express warranties, some express requirements. You need to do a site safety induction. You need to tell me if there's ever an issue. You might be saying to your employee, notwithstanding that I'm sending you to work for someone else, if you ever, find yourself in an unsafe situation, I give you full permission to leave and get out of there. So, client sites and labour hire, it's not you don't get out of jail free. There's no obligations, and they're always going to follow because it is your worker. But there are just limits on what you can do, and the law recognises that. So come back to your obligation. Do what is reasonably practicable to keep them safe.
Exactly. And remember, there are multiple duty holders under work health and safety laws too. So, those clients or the hosts will also have obligations under law. That's actually all we have time for today. We hope today's webinar has been really helpful for you, and sorry if we weren't able to answer your questions. If you would like to, as James mentioned at the beginning, we'd love to hear from you. We'd love to get your feedback on the webinar. So feel free to submit your details in the survey that's going to pop up very shortly to give feedback. And if you'd like to learn more about how LegalVision and our membership or desk extension can help you in your business, that's a good time and place to do that as well. So thanks very much for joining us, and hope you have a great rest of your day.